Hello everyone, thank you for taking your time and watch this uh, presentation on Muno Consult. I also encourage you to watch other videos and also try to subscribe. I'm making this presentation in response to the publication of New Vision, which is Monday, 27th May 2024, page 22, New Vision. The heading is address rampant land dispute once and for all. And to me, this is a claim that is impossible, or else we are getting another opportunity to test a bad or poorly informed land regulation, as we shall see in the presentation. Therefore, let's dive in. The presentation is going to be conducted under three themes. The first theme is the historical context, because in Uganda we have people who are known as Mailo owners and occupants. So we are going to see what's the source of the conflict between these two categories in Uganda. Then we shall also look at the second theme, which is stakeholder and challenges. We are going to look at the different players in the land dynamics in Uganda, how they have been changing over time, and how it has affected the political landscape of Uganda. Then finally, I'm going to also point at the basis. If you want to resolve land conflicts in Uganda, you have to first establish something I am referring to as the occupancy records system to inform your idea. Otherwise, any other thing somebody trying to do, claiming that they are cleaning up Buganda of disputes, my friend, you simply reason ash. In 1900, the colonial authority registered all Uganda's land territory under only 0.08% of Uganda's total population. You heard me right. A small percentage of people obtained deeds, leaving 99% plus in Uganda with unregistered land or interests on land, and also informally regulated land. On the surface, this looks an injustice. However, the colonial authorities had a bright idea. They taxed the landowners to make the elite find more occupants and boost coffee production, although the Uganda aristocracy thought they were getting land donations. But the British plan was the additional occupants would assist with paying taxes and producing coffee. Interestingly, though, this well thought out tactic made things worse for the elite. When the demand for land increased and created competition for the original occupants, the occupants became enriched by the resident Busuulu and Nvujjo as landlords wanted profit. The whole thing testified into a whole-fledged rebellion that gave rise to the 1927 Busuulu and Nvujjo Regulation. The issue of unregistered land interests for the occupants and unregistered land occupancy at this time becomes a pivotal factor in Uganda's political landscape, influencing loyalty and governance strategies. So, in 1927, the British come in as a moderator to protect the occupants from the greedy landlords, and also to protect the landlords from the hostile occupants. And this is the situation until 1962, when the British were granting Uganda its independence. And what changes around here? The British established the Buganda Land Board, which was supposed to be in charge of official Mailo land and Crown land. But after 1962, in 1966, President Milton Obote abolishes the kingdoms, and the Buganda landlord, the landlord who was in charge of the Mailo under official Mailo and Crown land, can no longer officially track what's taking place on that land. And that situation continues up to 1975. In 1975, under President Idi Amin, leasehold tenure replaced the Mailo land tenure system, which was abolished by President Amin. However, because of the ineffective implementation of this new system and the lack of official registration of occupants, President Amin left most Ugandans in a condition of legal ambiguity regarding their land ownership. So the occupants were not interested in getting leases because they also wanted to register their land for perpetuity. Also, the landlords did not want to get leases. So President Amin leaves power when nobody wants to register land under his tenure of office. And that takes us to 1995, when President Museveni and NRM formulate the 1995 Constitution. And in that Constitution, they show some love to us land occupants by branding us as bona fide occupants. The catch was that you had to have camped on the land for at least 12 years before 1995 Constitution. But the challenge is that the NRM government, as they were branding us bona fide occupants, they didn't double check with landlords or occupants to create a solid information system regarding our status. Where are the land occupants? Who are they? And how are they? They didn't do that. So they only had a record of the landlords, but not the occupants. And if you look at it, it's like NRM gave us VIP tickets without a guest list. And now that is the originator of the chaos of today as far as land issues are concerned in Uganda. Let us look at stakeholders and current challenges in Uganda land issues. The first stakeholder we are looking at are the registered, or what we call the landlords. I'll not call them official, because the difference between these guys and us occupants is that for them they have registered land interest with the government, while for us we don't have registered land interests with government. But if you look at history, they are not the right guys. They are just the registered guys, people whom government knows about their interests. But according to the 1995 Constitution, it's not that our interests are illegal. They are very legal and valid, only that government has not taken time to calm down and get information about us. And it keeps around making uninformed decisions and policies day in, day out. And that needs to change. Although the British colonial powers established the 1900 Mailo landlords as a tax collecting entity to manage crop production estates, in other words, creating conditions to attract occupants and increase production. Today's landlords including those with freehold, customary, Mailo, and leasehold titles, are evolving into private owners with no obligations to the government and diminishing responsibilities towards the occupants. These contemporary landlords often do not engage with or accommodate the interests and needs of the occupants. So you can see now the problem is coming in. At first, when land was being registered, actually the goal was to attract us occupants. But as things are changing, the landlords no longer want us. They don't want to associate with us. And nobody is tracking this, and it's happening. So something needs to be changed. Still under stakeholders and current challenges in the Uganda land issues, we have the second stakeholder as the occupants. Since the government failed to establish local centralized, formally regulated systems for occupant information in collaboration with landlords and occupants, bona fide occupant became a catch-all from grabbers and invaders to settlers and original occupants. This reference absence sparked hostility between landlords and occupants, leading many occupants to seek refuge with local councils, who now act like mini landlords, issuing land agreements with the trustee LC1 stamp. These are agreements often missing the landlord's consent and are legally questionable as a $3 bill. Yet we've seen cases where these legally flimsy agreements, sans landlord approval, have been used to make ownership rulings. It's like using a grocery receipt as proof of property ownership. Questionable at best, but it is the norm. Now, this is my question to you people in charge of policy, the MPs and other leaders. Will the law pass the test of morality if it declares all Ugandan Ndagano land owners evictable according to the 1998 Constitutional Review? Of course, reserve your answer. I want you to give an answer when you have information concerning Ndagan land owners, people who have sold out their occupancy and resold it, and the government cannot notice because it's not tracking this information at all. Still under stakeholders and the current challenges in Uganda land issues, we have number 3 as the authorities. These are mainly the local council committee or the LOC1 committee and also the LOC2. These local leaders are the de facto political managers of occupant affairs and function as mobile information systems of occupancy inventories. However, managing large, complex and sensitive issues overwhelms them. This situation, which ideally requires technical management skills such as surveying and information management, makes them prone to errors, potentially creating further conflicts. Additionally, the lack of a permanent village or parish central information reference point means occupancy land information is not accurately transferable to new political leaders, which leads to information loss, inconsistent occupancy agreements, resource wastage, and poor decision making, ultimately posing security risks. So the current situation, the LOCs are not secure, money of the buyers of occupancy rates is not secure, even the occupancy of the occupants who President Museveni baptized bona fide occupants is not secure, and I'm sure that's a security risk. Finally, under stakeholders and current challenges in Uganda land issues, let's look at the sources of credit. During the colonial times, it was the colonial masters, the colonial government. Today, we have lenders, informal and formal. Now, for the colonial masters, land titles were acting as promissory notes. You have a land title, but in return you must give certain amounts of coffee and taxes to the government. But today, you carry your evidence of ownership to the lender, and that acts as security to give you money. Due to informal regulation, susceptibility to errors, and the inefficiency of human data repositories if used as a reference for ownership, lending institutions are rationing our credit, hindering our access to capital, and thereby stifling economic activities. Now, few Ugandans can use land to access loans. Why? Those with titles, a good chunk of the titled land has occupants. Some of you call us squatters, grabbers, invaders, but you, based on data, let government come for information and then we get sorted. Now, you also find problems, those with land titles. Now, for us, the occupants, even if you honestly own the land, the bank will give you a small amount of money because it has no formal point of reference. So I'm requesting government that as you look at things like PDM and what have you, trust me, you'll create much more money if you create for us a formal point of reference. Finally, for this presentation, or this first series in the ignorant laws in Uganda, let's look at the roles of parish and village council occupancy records in sustainable land management in Uganda. Number one, accurate occupancy records. This will ensure precise documentation of land ownership, boundaries, and usage, reducing disputes and ambiguities. You know, some of the chairmen and other stakeholders who get arrested, in most cases they get arrested because they lack accurate land records. Point number two is the efficient land management. It will facilitate better planning and utilization of land resources, supporting sustainable development and conservation efforts. In most cases, you see people talking about development in a picnic style. Somebody poses under a camera and they talk about Vision 2030, 2040, 2050. But for example, I want a good mathematician to sit down and calculate the amount of mortar, that is sand, cement, metal bars or iron bars, building materials used in Kampala as a city. All of them, whether in Katanga, whether in Kololo, then compare with the amount used in Dubai. You might find that the cost might be the same, but the only challenge is that in Dubai, people have a plan. In Kampala, we don't have a plan. Why don't we have a plan? We are carrying the colonialist mentality. We don't want to track what's happening with our very good friends and partners in the development, the land occupants, of which I'm among. The third is conflict resolution. You cannot talk about transparent and reliable basis for resolving land conflicts to ensure fair and equitable solution for all stakeholders. When you are not involved in the tracking, how are these transactions evolving? what's taking place. I see people running away from the LC1 chairman, going to State House to resolve a land conflict. Of course, at times the chairmen are not honest, they are dishonest, but also the State House has no point of reference. It is not tracking. So it goes to power. Who is more powerful? I mean, let us become modern. It is time to let the facts talk. Let us not use power. You know, some people say that Amanyi Tegaria. Yes, let the facts dictate the winner. Point number 4 is legal assurance. This will strengthen the legal framework by providing clear evidence of land rights, which can be crucial in legal proceedings. You know, lack of this information, you find courts struggling with land cases, because when it comes to occupancy rights, occupancy information, there is no point of reference. And the court at times, I suspect, they just leave it to continue until the two sides get tired or resolve the things amicably, because they are the only guys who might be knowing the truth. And either way you make a ruling, you might end up unfair. So you can see, you even make it difficult for the judges to pass quality rulings. Another one is economic developments. Just like you see land, if you allow occupants to register their interests, it will enhance the value of their property and also empower them with better economic opportunities by providing us with security and clarity in land transactions and investments. I have a case of a man who died. He was based in Mitiana. He died from massacre. He had entrusted his land agreements with a friend. So now, you know, for us occupants, we are so disadvantaged in that if I buy from your land and you give me an agreement and I lose that agreement, things become so terrible for me if you, the seller, decide not to give me another agreement. So if we have this central system, with time, it can be a source of proof that land was sold, and maybe we can file an original that can be issued in case somebody lost their initial original agreement. And that is a source of security. Even if you lose an agreement, even if your house catches fire, you are safe. But today, if you lose your agreement, you are in trouble. Government revenue. Of course, since you decided not to track the occupant transactions, you only depend on tax collections from those who are registering land related to customary, lease, freehold and Mailo. Now, majority of the transactions in Uganda, central government doesn't get anything. Majority. And it is the one in charge of regulating things, it doesn't know. But I'm only requesting you to do the math. If you just provide a central system to accommodate this information at a fee as government, how much resources will you have saved? How much money will you collect? Then finally, the last one is public accessibility. When you have this occupancy records system, we shall have public access to land information majority of land information, which will foster trust and ensure that whoever is making regulations concerning land makes informed decisions, and therefore these decisions are not likely to hurt either the registered landlords and the so far non-registered land occupants. Thank you very, very much, and I'm requesting you to follow for our next video. May you have victory in whatever you're pursuing. Thank you so much.